The most significant ambiguity that appears in many contracts is one that I've seen in its most extreme form in contracts prepared by non-lawyers. When someone is writing a short contract for the division of royalties or other income, they'll tend to write something like, Party A gets 25%. That type of language always leads to problems because it doesn't tell you 25% of what. That of what is an extremely important question. Of course, a well-written contract will spell out in great detail what should be included in calculating the 100% out of which the 25% will be paid. Modern contracts for important projects can have dozens or even hundreds of pages spelling out the of what. But that can lead to another problem because the more complicated the required royalty calculations become, the more likely it is that someone will misunderstand them or make an error in the calculations. Because keep in mind, the people negotiating the contracts are generally not the ones designing or using the company's accounting system. Every lawsuit starts out by filing what's called a complaint. This complaint was filed in the Superior Court of the State of California, County of Los Angeles. Here's a description of a complaint from that court's website. The complaint is a document which lists and describes alleged offenses committed by the defendant, the effects of those offenses, and the desired conditions for the offenses to be corrected. Let's look at the complaint in this case. First, it lists all the plaintiffs. Then it says, plaintiffs allege as follows. This is a direct quote. This case presents an extraordinary example of how enormous financial success can breed unabashed and insatiable greed. That's a very dramatic opening sentence, but from the court's point of view, it's useless. You'll recall that the court said a complaint should list the alleged offenses. Greed, no matter how unabashed and insatiable, is not itself a legal offense. If the complaint stopped there, the case would be thrown out of court. But it does go on to list the specific offenses that New Line is alleged to have committed. I'll summarize each of those, but I found it interesting that the Tolkien estate spiced up their complaint with numerous derogatory descriptions of New Line's conduct. It's an interesting mix of terms in that some have legal significance, but others have more of an emotional than a legal impact. New Line's conduct is variously described as rapacious, improper and unlawful, close-fisted, fraudulent and wrongful, malicious and oppressive, illegitimate, fraudulent and unjustifiable, chicanery, and avarice. I wonder whether the plaintiffs included such language to help the court or because they knew that members of the press and general public would probably be reading it. Purple prose aside, what has New Line done that a court might consider wrongful? The complaint's introductory section points out that New Line has reportedly earned nearly $6 billion in gross revenues, but hasn't paid a dime to the estate. New Line has justified this, according to the complaint, by improperly understating income and overstating expenses. One way they've done this is by making deals with their own affiliated companies, for example, paying high fees to their own affiliates for advertising and distribution. They've also failed to allow the estate to audit their records for The Two Towers and Return of the King, and they've destroyed some records, so the estate can't tell what they're owed. You may have noticed that both the complaint and the answer are doing what's called pleading in the alternative. You are allowed to make different claims that are not consistent with each other. So if the court doesn't agree with one of your claims, you haven't lost the right to make the others. For example, if someone filed a complaint against you that said, I lent you an antique vase and you broke it, it's perfectly legal to file an answer that says, I never borrowed your vase, the vase isn't broken, and it was broken when I borrowed it. This is kind of what the estate is doing in their complaint when they say, more or less, we have a right to terminate the contract, and the contract is unclear and the court should rewrite it, and the contract is clear and we should be receiving royalties. CATCHA does something similar with their answer. They're saying, more or less, we didn't do anything wrong. If we did do something wrong, it's too late for the estate to do anything about it. The estate hasn't been damaged, and if they have been damaged, it's their own fault. Catch's answer and New Line's demurrer were filed with the court on August 4th, and, at least as of when I left home for DragonCon, no documents have been filed since then. So what will happen next? There's a hearing scheduled for, of all dates, September 22nd. I assume a coincidence, when Ann I. Jones will decide whether she agrees that some of the estate's claims should be thrown out. There are other hearings scheduled for October and December. Presumably both sides are gathering information, and it may be that one or the other will find something that gives them more of an incentive to settle. Right now, the parties might be discussing a possible settlement, but if so, it's all being done behind closed doors, and we'll only find out about it if they make a public announcement or advise the court that they've settled. I think it would make a lot of sense for the parties to settle. It's clear that the contract, as written, are not working. A judge or jury could try to figure it out and impose that interpretation on the parties, but then you risk having contract terms that neither party likes. Plus, neither the judge nor jury knows as much about the film industry as the parties themselves. Whether they can come to an agreement is the big question. Presumably, the estate wouldn't have brought this lawsuit unless other attempts to work things out had failed. Of course, if they do settle, the terms of that settlement would probably be confidential, and we fans would only know the terms to the extent that the estate or New Line chooses to tell us. Will the lawsuit cancel or delay the Hobbit films? I doubt it. For one thing, New Line and Peter Jackson and Guillermo del Toro, who I assume know more about what's going on than any of us in this room, all seem to be forging ahead, and I doubt they would do that if there were a big question as to their rights. Second, the contract's termination provision, according to one possible reading anyway, says it can only be terminated once there's been a final determination by a court that New Line has breached its obligations to pay the estate. Even if there is eventually such a determination, at the usual pace of litigation in the United States, that won't be for quite a while, and the production of The Hobbit will be well underway or perhaps even completed. At that point, it probably won't be in anyone's interest to try to prevent the film's release. So hopefully, in not too many years, we'll get to see on screen how things worked out with Thorin's contract. It may be that the Tolkien estate and New Line will never forgive each other, as Thorin forgave Bilbo for taking the Arkenstone, but I think that in our world, as in The Hobbit, things will eventually get worked out one way or another. As Bilbo said, even dragons have their ending, and so does my talk.